So let's talk about bank statements a little bit. In bankruptcy, when you file a bankruptcy, you must disclose all of your bank accounts. This includes bank accounts where you started a bank account with your teenager and now your teenager is above the age of majority and the two of you forgot to go back to the bank and take you off of the account. So you're still on this account with your child. So you have to disclose that bank account and whatever the contents are, and then you're able to explain, yeah, this money in here isn't mine, or this much of it is if you're actually using any of it. Same with your parents. Like if you're on a bank account with your mom, so that just in case she has a stroke and you need to be able to get into that account quickly and easily, you must disclose that account. And likewise, if you're not using it at all, you can still explain, I'm not using it at all, or how much you use, how much you've deposited will start to matter. And then you'll have to actually turn in all the bank statements, of course. Not all of the bankruptcy trustees ask for bank statements, but the majority of them do. So you must be prepared to turn in those bank statements. If you're a corporate officer and you have an LLC that you own personally, and so you've got a bank account for your LLC's bank statements have to be turned in and the amount of money in there disclosed. This is not something that you can toy around with and go, oh, no, that's my mom's account. I'm not the primary. Nope. If your name is on it, you tell them about it. And if your name is on it, you turn in those bank statements. Oh, my mom won't give me the bank statements. Your name's on the account. Go to the bank and get them yourself. If you're a signer on a corporate account for an S Corp, for any reason, you'll have to turn in those bank statements as well. Tell them about the balances in those bank accounts. And of course, it's not yours, it's corporate money, but you'll still have to explain it and turn in the documentation. What if I've got a corporation and I'm using a personal bank account as my business bank account? You still got to explain it. You still got to turn in the documentation, period. If the money in the account is not yours, if it's corporate money, you got to prove it. If you're running your payroll through a personal account, I don't know why your accountant hasn't beaten you over the head with a copy of the tax code yet, but guess what? Yes, you got to explain it all. That's what you got to do. And it's still corporate money either way. You just got to prove it, and you've made it a little harder. But you still got to, so you just got to prove it, turn in all the docs, and everything should basically be fine. Talk to your bankruptcy attorney if you don't have one. You should probably get one. And that's the way it is, because you must disclose. Real estate, it's location, location, location. Bankruptcy, it's disclose, disclose, disclose. So this is a little bit of a tip for how to file a bankruptcy on your own without an attorney, so that you can know that you must turn in all of the information that the bankruptcy trustee and the bankruptcy court and the bankruptcy code require of you. Second question, of course, is can you protect whatever is in those bank accounts? In California, and I'm only licensed in California, I don't know any law for anybody else anywhere else, you can protect a certain amount of money in the bank accounts, and it depends on a couple of things. If you own a home and you have a significant amount of equity that you have to protect in the home, then you're limited as to how much you can protect in the bank accounts. Unless it depends on the source of where the money came from that's in the bank accounts too. If the money in the bank account came from Social Security, you're fine. No one's going to be able to take that. If it came from workers' comp, you're fine. Nobody's going to be able to take that. And preferably, you don't commingle that money with any other money, so that then you have to do a complicated accounting to figure out how much of it came from workers' comp. You see what I mean? So the source can also matter. And how much you can protect, it's not a huge amount, but at least there's an amount that you can protect in a bank account, even if you have a lot of equity in a home. And if you have no equity in a home, you're probably going to be golden, because in California, they do give you a smallish homestead, which is worth about $33,000-ish. And you can use that as a wild card to protect anything that you want to protect, including just cash money sitting in a bank account, regardless of the source. Whether or not you can protect that, of course, I recommend you talk to a bankruptcy attorney. And if you can't find a bankruptcy attorney, You know something, if you just can't afford one, pro bono services are available through the bankruptcy court itself. Typically, in most areas, the bankruptcy court itself will have a pro bono program that you can plug into, get some actual help from a real live attorney who's been doing this for years and years and who can help you free of charge. So make sure you check into that.